certainly say you shouldn't have said anything. You shouldn't have an angry outburst. That's a bottom line issue. That's exactly that in the context of whether or not they should be charging.
Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, the people, Your Honor.
All right. Mr. Johnson, you're muted, sir. Go ahead.
May it please the court, Kareem Johnson, defending on behalf of Mr. Buckner.
All right.
What about that mention of anticipating the complaint? We're doing an arraignment.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir? And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction?
Sir, forgive me for my emotional upgrade. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are.
Freedom just snatched me, and I was understanding giving this son the right kind of charge. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay. And you said it wrong video, but now you tell me your video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson viewing the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th in Judge Washington court. Okay. Attention. I understand the attention. I just, from the time, and I apologize ever since, and I'm a little slow right now, so I apologize to the court at any time. Y'all be further ahead of me. Second to original charge. Second to original charge. Ms. Johnson, Ms. Washington, one final. Yeah. I understand, Judge. I'm sorry. I don't.
Okay, so you understand then the maximum penalties on that charge.
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Thank you.
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing. And Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
I'm staying in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I'm I don't want you to tell the judge to adjourn something. Then I need to be heard on it, and I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that the 22nd is not.
All right. So in that matter, preliminary examination will be in person. It would be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right. But I think that will be before Judge Washington. All right. And on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Pardon? Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
The allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the equipment. There was nothing I'm looking at. We can see the strongest. That means that he was trying to prevent this witness from coming to court and testifying, trying to change what this witness had said. All of it goes to whether that witness would be able to appear in future court. Taking it best, heard of the prosecution. Said you've been lying on me. The setbacks, my client is not saying he said that, but what the prosecution says that she killed you or something to that effect. She shoots you or kills you. Yeah, the notion is for threatening intimidation is that he has to be doing something to prevent this witness saying, don't come to court, trying to stop this witness. I think even if we hold her to this allegation based on her, I don't think the prosecution should be able to make out a case. His intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's the necessary. Because I do not believe that he will be successful in the conviction, I'm asking the court set for my client the personal cognizance bond. And here's the reasons why a personal cognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 680 box. It's not having anything to do with money witness lives separate. He's self-employed, he raises dogs, sustain himself. He suffers from numerous bad living networks already being raised that he's been shot on. So he's got health problems that arise with that. Finally, he lives with his autistic needs he has to take care of. He also has a brother who can help him make sure that he returns to all future workmates. It's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that probably
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is first this Tuesday. At that time, the victim testified at exam. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with the firearm by this defendant. Based upon this defendant's conduct, under people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim. And here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no go-to order as for a residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is greatly concerning, and to our mind points to a need to set a significant bond to secure the safety of the public and of the state.
So I'm response, John.
Yes, sir.
Obviously, very clearly, something different in the prosecution that they described it as an angry outburst. It doesn't rise to showing any attempt to keep anyone doing anything except that angry outburst. They went ahead and tried to charge witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try to just hear it, show the prosecution is that the court takes into consideration the likelihood of conviction. I think the likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun to something based on what they saw in the context of unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper conduct, you'd agree.
That's right. It's making a bond with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with this discretion, if they decide in the context of whether or not they would likely to get a conviction based on that flimsy information they have there, that's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to me and say, oh, well, we've got a new case based on that.
So there seems to be a misperception because the victim testified at an exam that somehow this conduct was not supposed to be the victim. The victim's testimony would be needed at trial as well. And to make this statement, not only that he accused her of lying, but that he was going to get her. When the same victim has seen this defendant firearm at her and rack the weapons, clearly the intent here was to intimidate the witness. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post yes or GPS tether, it will go conditions as to placing employment residence to the victim. But very clearly, this defendant.
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E. The first name. Hudson,
Say again.
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
Anything else?
No. The way it works is it's on a motion, you make a response, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm gonna order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment, or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established. But $75,000 on that case. Thank you.
It's possibly from Judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington couldn't help me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, the community of people that was helping me, sir, and I know everything I'm saying, but you already made a decision, is that the video inside Judge Washington's courtroom, Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown.
Yes. Thank you.
No, I don't, but I conditions. Okay. All right. Thank you, Mr. Brown, and I appreciate that lesson on how to conduct a court. No, I always appreciate the help. No, well, some places do it that way. I just let people talk. Okay, you know that because you're still doing it. Okay. Have a good evening. Is the person out?
Yes, that's Mr. Bruce.
Oh, is he into? All right, court does call the case People versus Rick Artuso.
Andrew Childers, on behalf of people.
And good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Artuso.
Where is he?
He was there, yeah.
This is Mr. You see him? Okay. Counsel, do you know where your client is or?
He was there, Judge. He called my office and asked where I was because I was stuck in Oakland Circuit, and obviously the court said I could appear by Zoom at 2. But I don't know where he's at exactly right now, Judge. Do you want? I was going to set it for exam. I know I'm in contact with him. Do you want me to waive his presence or pass for a second?
Well, unless the people have an objection, I guess what I would be inclined to do is adjourn it out a week.
That was I don't have the objection. My suggestion would be turn the PCC a week.
Yeah.
That's fine, Your Honor.
All right. Probable cause conference in this case will be adjourned to April 10th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right.
Notify my
Thank
client.
you.
Thank you, Judge.
And I need Mr. Ford out. Court does call the case People versus Alton Ford.
People.
Good afternoon, Your Honor. Staff, trying to put the docs, 795. What's it?
All right. Date set for a preliminary examination as well as a show cause counsel regarding your failure to appear at previous proceedings.
Yes, Your Honor. I do apologize. I thought this was PCC and exam, but I do apologize. I did try to check the date. I don't have Odyssey, and I did, so it was tough for me.
I think it was more than just one date.
The other one, I didn't have my substitution. I finally submitted that.
All right. And you're,
I'm going to ask for another PCC on and getting videos, which come via mail. They haven't reached my office yet. Just so we can determine it's fine. That's okay with the board.
with reference to the show cause before I adjourn it out, I'm not going to issue any sanction. However, would give you the admonishment that this court's expectation is that you will be here to represent your client. And he didn't know where you were. He had some confusion about that. And I don't think any attorney should place their client ever in that position.
He did an accident, Your Honor. I think that's what happened in the parking lot. Somebody hit my car, and I just write the date down. That confused me. So I apologize.
I'll adjourn the probable cause then to April 10th, 2025
Thank you, Your Honor.
at 9 a.m. or as your invite indicates. All right.
Yes, Your Honor. Thank you.
All right. Bond will continue. Thank you, Mr. Ford. What? That's it?
Yeah.
Oh, I'm ready for more. No? That's it? Really? We're done? Fine job you did, Alan. 14A stands adjourned. Thank you.
All rise. The 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Simpson presiding.
You may be seated. Oh, Simon and Brown at the table. That's Court calls the case of Beaver versus Elizabeth
That's
Black.
waiting in front of Slays. Yeah.
Ellen is on behalf of people.
And good afternoon, Your Honor. Ben Welski appearing on behalf of Elizabeth Black. I'm standing to my right hand.
All right, what are we doing?
My understanding the defendant is going to be pleading no contest to count 2 to sentencing under 4A. And count 1 will be dismissed.
That is correct, Your Honor. And you do no contest plea reason being Black are to civil liability.
All right. And understanding that I can't bind I would not be the sentencing judge, but I can't bind Judge Washington to that sentence, but I don't know why she would allow it. All right. Very good. I'll take this one.
Right. You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Elizabeth Black.
All right. It's the court's understanding that you're going to plead no contest to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that? Do you understand what a no contest plea is? All right, two things about it I have to make sure you understand. The first thing that you need to understand is it means that you're not further desirous or wanting to contest this case. You understand that? All right. Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that? All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that? All right. Now, understanding all of that, you still wish to plead no contest? And to that charge, how do you plead? Now, you understand that by pleading no contest, you'll not have a trial of any kind. All right. You had signed an advice of rights form, is that correct? This one? All right. Any questions regarding any of those rights? All right. Look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. All right. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 256675. Any objection to the court having reviewed that report? Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
You are satisfied, Your Honor.
That's satisfactory.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 5th, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you. Court calls the case of the people versus Ashkan Khan.
And once again, Your Honor, Khan, stating to my right, sir, raise your name.
All right, what are we doing in this case?
Your Honor, today's the set up probable cause conference. At this time, we are asking for a PCC date. I explained to my client that he does have a right to have his exam. He said voluntarily. Maybe not right. Is that correct, Mr. Khan? And we're hoping to have a resolution in the next court day.
All right, how much time did you guys need? 3 weeks?
3 weeks.
3 weeks. Without objection, April 24th, 2025, 9 a.m. Bond with its conditions will continue. All right, thank you. Court calls the case of the people versus Philip Carson.
Your Honor, Joe Simon on behalf of Mr. Carson. Bill Carson.
Mr. Simon.
Your Honor, we're asking to adjourn the PCC. We'll continue our negotiations. It's going to reach out to the complainant. My request.
Probable cause conference, April 17th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Thank you. Thank you. Court calls case people versus Mitchell Marion.
And Your Honor, for the record, Joe Simon on behalf of Mr. Marion. Mr. Marion, state your name. Mitchell Marion.
All right. What do we do?
Very similarly, Your Honor, I was talking to Ms. Duffy. She's trying to reach out to the trooper in the case. Hasn't been successful. Your Honor, can we go to the 24th? I know how you wrote on a request a specific date, but on this one, can we go?
No.
Fair question, fair answer.
April 24th, 2025, 9 a.m. Fine. Bond continued.
Thank you.
Thank you. Thank you, sir. Court calls case of the people versus, is it Jaming Tang? Jaming Tang.
Alexander, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Tang. Mr. Tang, please state your name.
Okay.
Requesting this matter be set for preliminary exam, Your Honor.
All discovery is complete.
It is. However, I
Oh,
think
here we go.
interpreters might be needed for both the complainant and my client. My client speaks very good English, but it's nuances that he doesn't catch.
And that's correct, Your Honor. We will also be,
And that's usually supplied by the people, right? And then your client is going to need an interpreter. Were you
Yeah.
planning on supplying one, or were you wishing the court to provide one to you?
Asking the court.
Of course you are.
It's Mandarin. I don't really have access to it.
Yes, you do. You just don't want to do it. His language is Mandarin.
Yes.
We, this goes to somebody else. Like, well, how are we gonna make sure that the phone includes shit order?
Yes, sir.
Okay.
You're good at it.
People had their witnesses available the 15th.
we'll do our best, Your Honor.
So set preliminary examination in person, April 15th, 2025, 9 a.m. before Judge Moore. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus Deshaun Tompkins.
That's the last people.
For the record, Your Honor, Joe Simon of the Sean Cochran.
Thank you.
Your Honor, I just substituted into the case and asking for a brief adjournment.
Okay, Simon, does it need to go to the 17th or 24th?
There was a particular reason.
I don't believe that.
It depends on how much you want to see me on either day. Which
I'm not gonna answer. I'm not falling for that. I'm not gonna answer that. Probable cause, April 17th, 2024.
Thank you. Your Honor.
All right, bond will continue with its conditions. Thank you.
Thank you.
Court calls the case, people versus Romario Buckner.
Joseph is on the case, Your Honor.
Good afternoon, Your Honor. Robert J. Kilwald on behalf of Mr. Buckner, who should be approaching the podium.
Yes. State your name.
Judge, in this matter, can we set an exam? I believe we have all the discovery, and I've spoke to my client about that.
People have their witnesses available the 15th.
Judge, can we make it
Preliminary-
the following, can we make it the following week possibly?
Preliminary examination, any objection to that from the people?
No, Your Honor. Was it the 22nd, Your Honor?
Yes. Preliminary examination, April 22nd, 2025, 9 a.m. That's in person before Judge Washington.
Thanks, Judge. Appreciate it.
Thanks.
Romero,
Bond
I'll
will-
call you later.
Thank you, sir.
Thanks, Judge.
You're welcome. Court calls the case of the people versus Andre Flores Nava.
And then on behalf of you, Your Honor.
And good afternoon, Your Honor. Joseph Hall, appearing for and on behalf of Mr. Flores Nava, who is appearing via Zoom with no objection to appearing in that manner. Mr. Flores Nava, if you could state your name for the record, please.
Andres Flores Nava.
Thank you very much. Your Honor, at this time and date, I spoke with Michael Vincent, who confirmed for me that we are awaiting the call for service and dispatch recordings on this before we can tell Your Honor that we've completed discovery. We'd ask for an adjournment so that we can pursue that discovery.
Without objection, probable cause conference will be adjourned April 24th, 2025, 9 a.m. Bond will
Beautiful.
continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Who was talking about me?
That too,
You don't have
Judge.
you don't have to
Mr.
laugh
Flores
that
Nava.
hard, Paul. All right.
You're okay to log off, Mr. Flores Nava. We'll give you a shout later.
All right. Thank you, guys. Have a good rest of your day.
Thank you.
Court calls the case, people versus Michael McClure.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. McClure, who appears by Zoom without objection. Mr. McClure, if you could state your name for the record, please.
Michael Thomas McClure.
And thank you, Your Honor. On this case, I just spoke with counsel yesterday. This case required a protective order before they were willing to hand over discovery. That's Fine by me. I sent it the earliest possible moment. I believe brother counsel got you that order today. So if we could adjourn to that same 24th date, Your Honor, I think that would work for our calendar.
I have signed the order.
Yes, yeah.
Ah, beautiful.
April.
That
wish
time it
you
was
quit
you,
talking
Judge.
about me.
That time it was you. Yeah.
Yeah, okay.
We'll get it set up as possible.
April 24th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you so much, Your Honor.
Thank
Take
you.
care. Take care, Mr. McClure.
Thank you too.
Yep. Bye.
Court does call the case of the people versus Kendall Warford.
Joseph, any other people, Your Honor?
Good afternoon, Your Honor. Attorney Ron McCool on behalf of Ms. Wolford. Ms. Wolford, tell me your name, please.
Kendall Wofford.
Thank you. All right, what are we doing?
Judge, we're asking if the court would consider giving us 2 more weeks for continued negotiations. We've been in frequent contact with the prosecutor. They're still waiting on some information on their end, but we'd like just ask for 2 more weeks if we could.
Without objection, April 17th,
Thank you, Your Honor.
2025, 9 a.m. Bond will continue.
Thank you, Your
Thank
Honor. As far as mom, may I ask one question, if I may?
Sure.
Last time I was here, I brought up the subject that she's testing Shelby District Court 5 times a month for ETG for alcohol. You had indicated after I asked if she could discontinue the tether with this case, that community corrections could come up with that solution, or if the people were okay with it, you seem like you'd be okay with it. I immediately reached out to community corrections. I emailed Mr. Bennick. I haven't heard back. I've also sent a copy of the bond order for Shelby to both the court and to community corrections and the people. We're just trying to get her to have less of a cost here, Your Honor. She's double testing. Can the court require or ask community corrections to dig into
Why
this?
don't you do this? Why doesn't the only issue is going to be whether or not the testing meets a particular level. But it seems to me that other testing that she's doing is court ordered. Is it right? Is that right?
Correct. It's correct.
All right. So I'm going to make an assumption. So prepare an order for my signature that she can test with results. She can test there with results going to our community corrections. All right. And then that way we'll just work it that way. If somebody, if community corrections has a problem with the standard of testing, then we'll deal with it. But let's just try to get that done. And we'll work it.
I will prepare that order that she can test with that court for community and send it to community corrections, and that she can discontinue the tether with our.
Right. Part of that order would be that she would execute any necessary releases for that information to go to community corrections.
Understand. Okay? All right, will do. Thank you.
Thank you. Court does call the case of the people versus Andrea Bukovich.
Richmond for people. The first one, yeah, and you see here with Bitch, who is on the Zoom. Please state your name, please.
Ma'am, could you state your name, please?
Yes, Andrea Butkovich.
Okay. And what are we doing?
So, Your Honor, this time I have reached a plea negotiation if it pleases the court with the prosecution, and I will let record.
Thank you, Your Honor. This case previously adjourned so that Ms. Butkovich could legally pay the requested restitution amount or to reach a misdemeanor resolution. We have that today. The people have offered to dismiss count 1, which is 1 count of uttering and publishing, in exchange for her plea to attempt check no account. That pack code is 750.13181. That will make it a 1-year misdemeanor.
Do I have the plea
I'll
form?
get ready to sign it and I will, no, I don't know if she's going to guilty or no contest.
Do we have a choice?
Just about 6 check.
She already paid the restitution, so I don't think but we'll do the no contest.
Okay, so if you're gonna plead no contest, I'm gonna need a police report. I don't have a police report. I don't have anything.
We want to get this resolved.
Okay. The plea form that I have before me indicates that the defendant will be pleading guilty to an added count 2 of no account check, the 1-year offense, or attempted no account check, the 1-year offense. Is that really a 1 year, the attempt on that?
The felony is 2 years.
The 1 year offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's entire understanding of the, is that correct, counsel?
Yes, Your Honor.
Ma'am, could you please raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Andrea Budkovich.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted no account check. That is a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court cost. Do you understand that?
Yes, I do.
All right. Court further has to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to this charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 if you have a copy. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on the form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes, sir.
July 17, 2024, at the location of 22882 West Liberty in City of Ann Arbor, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty of this offense?
I had.
You may voir dire.
Ms. Budkovich, did you go to a place called Convenience Auto Service located on Jewett Street?
Yes.
Okay, and did you submit a check to the owner, to the business?
Yes.
And was it in the amount of $616.77?
Yes.
Okay, and did you know that that check was not a legitimate check?
Yes.
Okay, and did you attempt to pay for the tires? Did you purchase anything at that business?
Yes.
Okay, and did you attempt to pay for those purchases with that check?
Yes.
Okay, Your Honor, I think.
Thank you.
I'll accept that plea to the higher charge, actually, by the inquiry. If I do that, counsel, have I complied with the court rule and would be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be April 29, 2025. Time again, I'm sorry. 9 a.m. before Judge Valvo. Bond will continue.
Your Honor, there's no, I would have to contact Judge Valvo regarding the scheduling, correct?
Yes.
Okay.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case. People versus Desiree Walker Johnson.
Siegel. Carolyn Foster Chuck on behalf of Desiree Walker Johnson. Can you, Desiree Walker?
All right.
And Your Honor, we're requesting a preliminary exam.
And is all discovery complete?
To my knowledge. I believe so. There's one other thing I'm gonna check into, but I don't think we have it. I don't think it's ever provided, just to make sure, but we should be fine.
And people would have their witnesses available the 15th?
We'll try.
Preliminary examination in person, April 15th, 2025, 9 a.m. That is before me. Bond will continue. Thank you. Court does call the case of the people versus Dijon Williams Watkins.
Take a look at feedback, so 166. care about what happens to us, it's gonna do some stuff, it's John Wayne Roberts.
All right. You're requesting an adjournment of these proceedings?
Yes, sir, we got a report back that he's competent to stand trial with us, so now we would like to see the people that have offered, so we'd like to see where they are.
You have this set for a competency or
Yes, sir.
today?
Yeah.
It's already.
You have it set for a competency. So first thing I guess we have to do is, I'm in the receipt of the report dated March 3rd, finding incompetent. Is that the one we're talking about?
Yes.
Did the party stipulate to that report?
Yes. Yes.
All right. There being no additional evidence, the court would find that the defendant is competent to stand trial, would further indicate specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Sir, I'll need you to prepare an order to that effect. And now you wish to set for a PCC at some point?
That's correct.
All right. Set a probable cause conference. Will the 17th or 24th work better for you?
Those dates, and we do first of May now.
Any objection from the people to going to that day?
Okay.
May 1st, 2025, 9 a.m.
Thank you.
Thank you. Bond will continue. Thank you.
He's not,
Burgess.
yeah, he was provided this information too.
Do we know where he is? Who's on the other side? Have you heard from Mr. Burgess at all?
No, no.